For those who don't know me, my name is Bill Berkwhite, and I'm a professor here at the law school and the director of the university's International Affairs Institute, Perry Worldhouse. I also occasionally dabble in the world of international arbitration and sometimes teach the investment law course here. And I am therefore honored to get to introduce our speaker, who's someone I think of as a friend as well. And he's someone who really there is no introduction that I could or should give. I could read you the list of awards that he has won. I don't think there is an award given by any organization in the field of international arbitration that he has not won. He leads the International Arbitration Practice Group at WilmerHale. His life bounces between London, New York, Berlin, Asia, and I seem to find him on all corners of the globe at all times. There are moments when I look at his list of publications that I simply say, how can he do it? He is the author, as many of you know, of International Commercial Arbitration, the leading textbook in the field. When I was in law school, I was handed International Civil Litigation in U.S. courts, which was the first time I ever saw his name, and he still is the author of that. He's a deep thinker. He is someone who teaches as well as practices. He has figured out how to bridge the academic and policy and practice worlds like no other. He has also really shaped a generation or more of young arbitrators and young lawyers. The fact that he is with us today shows you his commitment to education, his commitment not just to practicing, but to thinking deeply and thinking hard about these issues. It's therefore one of the reasons that we were lucky to ask him and for him to say yes to come and join us at Penn some years ago as a Bach Distinguished International Professor teaching a course on international arbitration. But we are not the only school to have been so lucky. He is a professor at St. Gallen, a professor at Tsinghua Law School in Beijing, and a frequent visitor to law schools around the country. He has also represented clients in or been an arbitrator in apparently more than 600 international arbitrations. But what's important is that they are the ones that have truly shaped the system. It is rare to have someone who has had such influence on all sides of the creation of a new system it's been around for a long time, but its modern manifestation has really been created by Gary Born. The most exciting aspect of this introduction for me, though, is that he went to a law school called the University of Pennsylvania. And I won't tell you what year he graduated, but I will say that he has really been one of our star graduates in so many ways, someone who has given to his field, someone who has given to the law school and continues to do so today. With no further ado, I give you the world's leading arbitrator, Gary Born. Welcome back to home.
So, thank you, Bill. That was enormously flattering, undeserved entirely. More importantly, thank Penn Law School for putting on what is truly a spectacular conference. You can see by the range, the diversity of the audience, the speakers, what a tremendous job Bill has done, and equally importantly, what all the students here in the Penn International Arbitration Club have done. It's a truly remarkable effort, and I thank them. I think on behalf of everybody here for putting on such a tremendous presentation. I'd like to begin with a bit of an apology. I shouldn't be doing this. Professor Catherine Rogers ought to be doing this because I want to talk about something that is both a tool and an idea. The tool is something called arbitrator intelligence, and see if I can do this properly. it looks a bit like this. And in addition to talking about the tool, I'd like to talk a little bit about the idea of arbitration and how it gives rise to this tool, and how the tool makes arbitration better, how it makes arbitration realize its true aspirations. I'd like to begin by thinking about what arbitration is. We can look that up in commentaries, and we can think about it from our practical experience. It's as we know from many contexts, it's a consensual means of resolving disputes by non-governmental decision makers chosen by or for the parties, applying adjudicatory principles that allow the parties an opportunity to be heard. The critical bit in that mouthful is non-governmental decision makers chosen by or on behalf of the parties. The thing that makes arbitration different, that has made it so popular, so important, is the selection of the arbitrators, the selection of the decision makers. That's how it's different from national courts. And putting aside the long, mostly boring commentaries, it's also what we know from practice. We know that the first thing counsel tells parties in arbitration that is the most important choice counsel will make in an arbitration is selecting the arbitrator. And how is it then that in practice arbitrators get selected? What is the reality of the selection of these individuals, these people who will be arbitrators, who will finally resolve parties' disputes? It's an extraordinary responsibility that arbitrators have, especially international arbitrators in many respects. They, as you learn from other commentaries, have the almost unfettered discretion to adopt procedures in particular cases. You think about what Article 19 of the UNCITRAL model law, what Federal Arbitration Act authority in this country says about the arbitrator's procedural discretion, and it's extraordinarily broad. I think Judge Easterbrook said that parties are free to choose arbitrators who will resolve the case as if by combat, trial by ordeal. And the procedural discretion of arbitrators is extraordinary. Their substantive authority is also extraordinary. In most countries under national arbitration legislation, the annulment authority of arbitrators is narrowly limited. It doesn't involve review of the merits. It's mostly true in this country as well. There may be some lingering notion of manifest disregard of law, but for the most part, once arbitrators decide cases, that's the end. It really is a final resolution of the parties' dispute. And for that reason, the selection of the arbitrator or arbitrators is extraordinarily important. And how is it then in practice that happens? How is it in practice that people actually choose arbitrators? We mostly know from big firm experience and anecdotal reports how in practice arbitrators get chosen. Big law firms who disproportionately represent parties in large international arbitrations will rely on their on their personal knowledge. They'll create, mostly the partners will create a list of potential arbitrators based on people they've appeared before previously, people they've sat with. They may ask associates to do research. The associates can then go off to a variety of sources. They can go off to chambers. They can go off to the Swiss Arbitration Association. They can go off to Legal 500. And they can come up with various lists of arbitrators. They can send ISOs in search of emails around the law firm, and they can call up their friends. They can then, in some cases, do research into publicly available information, read law review articles, commentaries, what have you. And they can come up with their profile of the perfect co-arbitrator and then the perfect presiding arbitrator for their case. In some cases, they can interview the arbitrator, the prospective co-arbitrator at least. And then based on that, they can make a recommendation to the client. This is a funny market. There is a market for arbitrators. It's a funny market in that the information that is most valuable tends to be controlled by a relatively small number of people, tends to be controlled by partners in large law firms, occasionally highly sophisticated clients, but that's only very occasionally. It is a market characterized by a lack of transparency. The partners in large international law firms don't particularly want to share that information. They have a monopoly on it. Part of what they sell, part of what I sell, is that I know who the best and worst and medium-sized arbitrators are. And other partners take exactly that same approach towards the information that they have and that they hold so closely. The publicly available information is a little bit difficult. It's expensive to get. You have to pay associates the hourly rates that they charge to go out and read lots of publicly available information. And the information that you get, at least in some areas, tends to be a little bit like what you get in the Senate confirmation hearings for Supreme Court appointees. You get information that has been produced with an eye towards its subsequent production in confirmation hearings, and you can question how valuable all that is. You also need to take all that information and look at it in the context of a specific case, a specific type of case, a particular industry, particular amount in dispute, particular set of institutional rules, particular arbitral seat, and try to figure out, based on that information, who the most favorable co-arbitrator from your perspective would be, who the least bad presiding arbitrator would be. This is a system, oh dear, this says no video input, please check cable. I'm sure somebody can, this will work. This is obviously a system that results in huge asymmetries between different types of lawyers and different types of law firms. It means that the major law firms really do have a strong advantage. It means that the more senior lawyers have a huge advantage, which in turn has I think led to some of the lack of diversity that we've heard discussed in previous sessions. And it has also led to some of the criticisms that one hears of of international arbitration itself. It reinforces the notion that international arbitration is the preserve of a mafia, a small elite, mostly senior European and North American practitioners. Is there anything wrong with this? Some people, mostly senior practitioners at major law firms, say there's nothing at all wrong with this. This is a great system. In fact, we ought to, as I'll say towards the end of these remarks, in fact, we ought to reinforce this system. We ought to give effect to some of the characteristics that ensure that it continues to function the way that it does. In fact, though, when you go out and talk to clients and others in the field, they have a very different view. They have the view that, in fact, there needs to be a change to how we appoint arbitrators. Not a change the way some have suggested, not a change that would take parties out of the equation, not a change that would move the appointment of arbitrators from the hands of the parties, but instead a change that would make parties more able to do what's so central to arbitration, namely choose the arbitrator who is who's best suited for the dispute. Arbitrator intelligence, which is the tool that I wanted to talk about, is the child of Professor Catherine Rogers. It is, and you can, if you look on your iPhones just now, you should Google arbitrator intelligence, and you can find it. You can find its website, and you can get from that website, probably, since she did it, not me, a better sense of what it does. It aims, as its mission statement explains, to promote fairness, transparency, and accountability in the selection of arbitrators, and as a consequence to level the playing field for both arbitrators and also lawyers in international arbitration. It aims to do that through technology and in a fairly, in some senses, simple, obvious way, but in other ways, very, very thoughtful, groundbreaking way. It aims to do that by creating a resource in which anybody, whether or not they are at a major law firm, whether or not they're one of the names that you would see in Chambers or Legal 500 or something like that, anyone can have access to more information than that self-announced elite has. Arbitrator intelligence will pull together for all plausible candidates for arbitrators. And that, of course, is a moving target. It's one that needs to develop over time. But it will pull together information about each person who might be an arbitrator, information about the cases that they have sat in, basic information about the time that it has taken to decide cases. And then, extraordinarily importantly, also feedback from parties in prior cases about arbitrators. One of the reasons that international arbitration itself gets criticized is that judicial proceedings are open to the public, of course, and therefore there's public scrutiny of opinions, there's public scrutiny of judicial proceedings. There are judicial almanacs, federal court judges, state court judges, other judges in this and other countries are the subject of write-ups from the lawyers who appear before them. There's no such thing for international arbitration. No such thing for international arbitrators, which, because arbitral proceedings are, for the most part, not entirely, but for the most part, confidential, means that you really don't know much about how individual arbitrators have done. Arbitrator intelligence will, working with arbitral institutions and arbitrators, conduct questionnaires of parties who have had arbitrators in cases before them, who will fill out relatively detailed lists of questions about issues that the arbitrators addressed, how they addressed particular issues. It will collect arbitral awards. It will get feedback from the parties about how well they think the arbitrators did. That feedback, like any feedback, needs to be taken with a grain of salt. In some cases, probably more than a grain of salt. People who lose arbitrations usually don't much like their arbitral tribunals. It's hardly surprising. But the questionnaire can identify that. There, of course, will be those who are hesitant about this system. But what it does about this questionnaire and about the process of getting feedback from parties to arbitrators, but what it does is dramatically increase the amount of information that is available both to lawyers, wherever they may be, and to parties. It enables them to make what is the most important choice in arbitration in a much more informed and intelligent way. I said this is not just a tool. It is a tool. It's about to go live. It is something that you will be able to use in real life. Law firms, I'm sure, will feel not just that this is useful, but that this is essential. How does one explain to a client if one chooses an arbitrator and the arbitration goes wrong, that one didn't make use of this tool, which will provide information based upon a wide range of responses about particular arbitrators? Why did one use the ad hoc, anecdotal information that one had from the limited experiences? Why did one have the arrogance to think that since you did, or your practice did 600 arbitrations, you shouldn't go look at 6,000 or 16,000 arbitrations to see how the person that you've recommended as the arbitrator really conducted herself or himself? I think law firms will be compelled to use this as part of very basic due diligence, and it will be a tool that everybody has to use. But it's not just a tool. It's also an idea. It's an idea in the sense that the process of choosing arbitrators has been criticized. Members of the elite, the folks that show up in chambers, have suggested that because of the issues that arise in choosing arbitrators, one should take parties and lawyers for parties out of the equation. Instead, have arbitral institutions choose the arbitrators. The notion being that the arbitral institution has more information, and the arbitral institution is more neutral and can do a better job, probably, is more expert than the parties. Those suggestions betray what's at the very heart of arbitration, and particularly international arbitration. And they fail to do what this tool accomplishes. Those suggestions ignore the fact that for literally thousands of years, parties have used arbitration precisely because it gives them the opportunity to choose the arbitrators. That is essential to arbitration. It's part of the definition. It's one of the most important reasons when you look at surveys of why commercial and other parties want to arbitrate, why they want to arbitrate, because they can have direct input into the selection of the arbitral tribunal. That allows them the confidence of choosing arbitrators who will be precisely suited to the characteristics of the dispute. The parties know better than anybody else what their dispute is about. They have the greatest incentive of anyone in the world to choose the arbitrators who are best suited for resolution of the dispute. Arbitral institutions have a certain expertise, but less incentive in the selection of arbitrators. I choose arbitrators because I'm president of the Court of Arbitration at SEAC. I don't do as good a job as parties do when they choose arbitrators. And suggestions, therefore, that one should take parties out of the process of choosing arbitrators threaten the entire fabric of international arbitration and contradict its most important objectives. Arbitrator intelligence does what those suggestions seek to do, namely improve the process of international arbitration, allow parties to make truly informed choices about who the best arbitrators in individual cases will be. The French Constitution of Year One guaranteed French citizens the right to arbitrate. It guaranteed them the right to arbitrate before arbitrators of their own choosing. That was a constitutional guarantee of the French Republic and is just as constitutionally important to international arbitration today. In order to make international arbitration today work, to fulfill the aspirations of the Constitution of Year One and of the parties that agree to it, tools like arbitrator intelligence are essential. I don't want just to promote arbitrator intelligence. I know it sounds that way. And I do have to disclose that I'm on the advisory board. The Global Arbitration Review, GAR, has a product that is also a useful complement to arbitrator intelligence, providing more information about arbitrators. But this tool is together with other tools like GAR's arbitrator selection tool, is not just a simple tool that lawyers can use in their day-to-day practice. It's not something that allows you to just deliver your services more efficiently and better. It does all that, but it does much more. It is a tool that is essential to the continued growth, and it has been tremendous growth over the last decades, but the continued growth of international arbitration. I'm sure there will be questions, and I invite them. Maybe there are no questions.
Is this tool on subscription?
No, I think the tool will in principle be free, but when law firms wish to acquire reports about individual arbitrators, they will have to pay. I think the fee schedule will take into account the characteristics of the users and their ability to pay.
Question two, should arbitrators check on their entries before it's published?
I think arbitrators should do that. I think these are good questions, and I think a dialogue between arbitrators and arbitrator intelligence about how precisely the feedback results from the questionnaire, which is central to arbitrator intelligence, is really important.
I better look up Griffith's dissent in RSM.
Everybody should look it up.
So this is under the presumption that the market failure would be lack of information. But what if the problem is also an agency problem, the way you appoint an arbitrator and the way that the general this system could also solve this possible market failure? Or?
I think this system can, and I think this goes back to observations that were made in the morning about diversity and the thought that, if I understood it correctly, that in-house counsel tended to appoint people like themselves and tended not to appoint people from developing parts of the world, younger arbitrators, women, others. I don't think this tool solves that, but I think it contributes to solving it. The reason it contributes to solving it is it breaks the mystique that surrounds the elite club of arbitrators, subjects them to the same scrutiny that judges are subject to, provides information about others who might not be in that self-perpetuating elite, allows them to be compared, and then when the general counsel is thinking about how to protect herself or himself, she has to reckon with the fact that there will be objective data that compares new people to old people. And in doing that, I think it democratizes the market for international arbitrators, which is a good thing. John.
Gary, this is probably a question I ought to ask Catherine, but
Yes.
This-
Like I said, I apologize. She should do this, not me.
you know, for years, the AAA, for example, has tried to collect information from participants in the process about, you know, their reactions to how the case was run and how the arbitrators did. They have found, you know, this has been going on for 20 years, that it's relatively easy to get a response from an unhappy losing party and almost impossible to get a response from a winning party, whether happy or unhappy, you don't know because you can't get an answer. How is arbitrator intelligence dealing with what I'll call the sour grapes problem of the sort of self-selection of who gives the input, which tends mostly to come from unhappy participants?
I think it's doing it in a couple ways, and Catherine can elaborate. One way of doing it is by working across institutions, trying to reach out to as many institutions as possible to regularize the process using the very questionnaire that you can see on the current slide. I think there's also a generational aspect to this. It is true that for the last 20 years, there's been the notion that arbitration is confidential, and sharing this information, I think, runs against the default presumption. I think that influences why parties don't want successful parties, partially successful parties don't want to respond. But I think that in part self-preservation, a notion that the thing we do, international arbitration, will thrive if we answer those questionnaires, plays an important role in this. I also think general counsel are changing in this regard. I think general counsel understand that a tool like this, their response to this tool has been highly positive. They understand that this tool empowers them as well as younger lawyers in other parts of the world, because it gives them information that ultimately allows them an equal seat at the table, along with the senior partners at big law firms that advise them. They, therefore, will have an incentive to answer these questions. Professor Rogers may have additional thoughts, though. She has a microphone, so.
I will just add a couple little things, which I think you did a perfect job of explaining. We are trying to essentially regularize response rates to the questionnaire, and we have a number of tools for doing that. And then also additional protections against the sour grapes problem, because that is one of the key concerns. So we actually will sort the data based on whether parties self-identify as winning or losing. So you can see, you know, if only losing parties, you know, trash someone, it might be different than if winning parties do, or vice versa. We will also, we have also really focused in developing the questions on the questionnaire on objective information. So was document production granted? Yes, if so, which standard was used? And then we do ask a subjective follow-up question. Do you think this was, from your party's perspective, too much, too little, just about right? So that's where the subjective concern comes in, but it's building on a series of carefully constructed objective questions. And so that's another way.
I didn't ask John to ask that question, but it naturally leads to looking at the questionnaire, which, notwithstanding my obvious technological deficiencies, I've gotten onto the screen. And you can see here, it's meant to be user-friendly. It's meant to be the sort of thing that someone on the team can fill out and has questions that you can answer by checking boxes. It may be, and John, you're right, it may be that there are hesitations in answering this, but I think it is presented in a way which makes it easy, not hard to answer. And for the reasons that both Catherine and I have said previously, General Counsel, the client, has an incentive to have this questionnaire answered. More questions?
Thank you. You mentioned that the idea of this tool is to, in a way, to level the playing field, and I understand it's about the leveling the playing field not only amongst the lawyers who do the counsel work when they select the arbitrators, but also giving the opportunity to diversify the pool of the arbitrators. I guess the question is that obviously if the tool is popular and successful, it would diversify the pool of arbitrators eventually. The question is when it is going to happen, because obviously the elite group of arbitrators would get just more feedback because they hear more cases than the newcomers to the field. And the chances are that the elite group of arbitrators will be getting more and more feedback just because they hear more cases, and the newcomers would be getting probably 1 or 2 hits a year. And to what extent this disparity will be addressed by the tool in any way?
Let me push a little on the premise of the question, which I think is, if an arbitrator has more results, she will be better regarded. And let me push on that, because I don't think that's necessarily right. You will get results in this that may be uncomfortable for the person who's being evaluated. If, to continue using our terminology, the elite arbitrator ends up with middling results, it's going to affect her standing. Whereas young arbitrators, who are appointed frequently by institutions, particularly in smaller cases, are also going to get results. And if their results are good, they're going to move up the food chain to not small cases, but medium-sized cases. That's not a bad thing. It's a good thing, actually. If you weed out the people at the top who actually aren't doing the job the way that they should, and promote people who aren't necessarily at the top to bigger and better cases, that's how, at least in my view, a system should work. The system's not aimed to divvy up spoils based on some presumptions about geographic diversity or gender diversity. It's aimed to find the best people as arbitrator. And over time, it ought to do that.
Part of the mission statement of arbitrator intelligence is, for all the right reasons, promoting diversity in arbitration. Yet one of the earlier panels today seemed to conclude that really the only way to achieve diversity, at least among arbitrators, is really to hand over control of appointment of arbitrators to the arbitral institutions. I was wondering if you would be willing to back that idea up, especially in contrast with the idea that you just talked about, which is party autonomy, and how this, again, rightfully so, is really one of the cornerstones of international arbitrations. Thank you.
Yeah, no, I'm glad to have the chance to re-emphasize that point. As I said previously, I think, however one puts it, handing over control of arbitral appointments to arbitral institutions, or alternatively, taking parties out of the process of appointing arbitrators goes to the very heart of international arbitration, and would, I think, betray its most important aspirations and would frustrate its most important users. I also am skeptical whether in the long term it would really achieve the objectives of diversity that it is sometimes described as being designed to achieve. I think, in fact, it's more likely, as has been the case historically with some arbitral institutions, it gets captured by a small group who use it to perpetuate their own nominations. I think an open market with access to good information, which is what arbitrator intelligence is designed to do, is a much better way to promote true diversity, especially in an international context.
Thank you. My question is actually a follow-up, I guess, to the previous question. And I was wondering whether this tool exists in just the English language, whether there are translations, and if there aren't, whether that undermines diversity, because all those arbitrators and parties who only speak Spanish, who only speak French, or whichever other language, are deprived of this benefit that can be derived from this tool.
Well, you know what they say. What's the world's most widely spoken language? Bad English. So you got to start somewhere. And we're starting with bad English. Obviously, as the tool develops, and there has been, I think, in the various parts of the world where interest has been keenest, extraordinary interest in South America. And I think Spanish, Portuguese versions obviously make sense. We got to start first, though, with bad English. There ain't no other choice. So, I think everybody's busy downloading their app, so we can declare it a victory. Thank you all.